Welcome back. Well, yes, indeed, you just heard about that. So that's what we'll start off with here today. And we've got Mr. Kolakbo Alimi, who is a lawyer. He's also a former commissioner for local government and chieftaincy matters in Osun State. Thank you for coming on this morning.
Yeah, good morning.
Well, what a judgment that is in a split decision. But I know that, yes, the government says, no, that's not all there is to it. They'll take it off from there. But you've gone through this judgment yourself. What's your immediate thinking about it?
Well, thank you very much. Let me first state that the beauty of our law is that there is hierarchy of courts. The tribunal is the court of first instance, where in this instance the case will still go as far as the Court of Appeal and the Supreme Court. Without giving my opinion first, I want us to dissect the judgments. When you are talking of no compliance, it must be specific. In the instant case, the election were cancelled in the 17 polling units because of the fact that in the affected 17 polling units, in the pin copy tendered by the petitioners, the column, the topmost column on the Form EC8A. Form EC8A is the resource sheet at the polling units for the purpose of information of our listeners. There is a topmost column there, which is meant for ballot paper accounting. There are about 8 columns. One of the columns there is meant for a number of accredited voters. The pink copy tendered by the petitioners, they were alleged that those columns were not filled. They brought witnesses, their party agents, who are in the court, who are at the various polling stations. They brought them to the court to come and give evidence.
Are you taking us through the entire process of what transpired at the tribunal?
No,
because we don't have all the time for
no, yeah.
Let's go straight to the judgment.
The judgment. So the main reason why the election in the 17 polling units were actually cancelled was for that reasons. All the witnesses that came before the court said election in their various units, they were free and fair. The accreditation done, voting done, sorting, counting, and so on and so forth. That's the first ground. The second ground is on the rerun. Both the minority judgment, let me say there are two, you call it split judgments. There are 2 judgments from the tribunal. The 2 members deliver their own judgment. The chairman disagree.
Well, when you say there are 2 judgments from the tribunal, some people may misunderstand
the minority judgment, we have to clear it. The 2 judgments emanated from the tribunal. The minority judgment and the majority judgment. And in that system, majority carried the vote. So when you want to talk about which one is the judgment of the tribunal, it is the majority judgment. But you cannot close your eyes to the fact that there is a minority judgment, which was actually delivered by the chairman. That would be the first time. The chairman of the tribunal himself. Now, it doesn't matter. And so, now let me now go there. What is now the ground on the second ground? The two judgments agree that the INEC has the power to declare election inconclusive, whereby the margin of lead between the winner and the runner-up is less than the number of accredited voters in the area where the elections were cancelled. But in this instance, they now went into the majority judgment now said the power to cancel that.
Yeah.
It said the power to cancel that election reside with the presiding officers and not with the returning officers of the state. Both of them are members of INEC. They are staffs of INEC. But the level.
Yeah, so what is your point now? That the judgment erred in law to have said that
yes,
the returning officer cannot cancel?
Yes.
Can the returning officer cancel it upon collation?
No, thank you very much. The only reason why the returning officer will not have the power to cancel the election, now my own opinion, is when there is evidence that election was actually held. Let me say that law is actually made to prevent arbitrariness. A situation whereby an election has been concluded in the polling unit and somebody somewhere will just sit and cancel it. But in this instance, both the petitioner and the respondent agree that election did not take place in those 7 polling units. So there was nothing to be cancelled. So the chairman of the tribunal, when you read the minority judgment, said the onus is on, I think, based on the evidence and fact before the court. There were no election in those areas. And so the issue of who has the power to cancel or not to cancel does not arise. It now said that, assuming they are even claiming the onus of proof that the elections were actually held in those polling units lies on the petitioners. He now said they failed to decide that one because a petitioner who wants to claim that the election has been held in a particular polling unit will come with the result of those polling units. All the authorities cited in those cases, the result were tendered before the tribunal. That these were the result of the election in our unit. Why were they cancelled? And that was the reason why the court said when an election has been concluded in the polling unit, a returning officer cannot state in somewhere and cancel it. But in this last case, part of the issue the court will determine now, the appellate court.
Because the majority judgment says INEC had those elections that held in those 7 units is unknown to law because INEC had no power to conduct it.
No, what the majority judgment says is this, that because INEC did not lead evidence, that when those elections were, if peradventure those elections were cancelled, that Form C40G ought to be filled, and INEC ought to come before the tribunal and tender those forms, that those elections were actually cancelled at the polling unit. You understand it?
Okay.
But the minority judgment said the onus lies on the petitioners, and that those elections were never held. And when you go to paragraph 24, and that is page 218 or thereabouts of the judgment, when you go there, you will see the evidence of PW 74, Dele Adeleke, who himself stated the reasons why the elections in the 7 polling units were cancelled. It means in those 7 polling units, there were no results to be cancelled in the first instance. In Orolu, 3 polling units, disruption of the election was not concluded, it was disrupted. In one of the polling units, because of a card reader, self-attachment card reader. In another polling unit, the presiding officer absconded. But the point is that the question is, in those 7 polling units, do we have results?
You know, well, yes, we're still going to dissect some of this, but, you know, when that judgment came through, there were several schools of thought, just as you've seen majority and minority judgment.
Yes.
So one of them, which is, and besides, well, let me even ask, what do you say to those who, as soon as they heard the judgment, said, justice is seen to have been done?
Thank you very much. It was based on wrong impression. And let me correct it now. People thought the rerun election was actually null based on what happened to the election. Go to the conclusion of that page. They said there was no any evidence led as per any corrupt practices in the main rerun. There is a sharp distinction between talking about, you know, the way they cancel the election is this. Because
is it the Osun 1 or Osun 2? Which one are you talking about?
The rerun is the happen to be the Osun election 2. It was all cancelled because of any corrupt practices. They are now talking because the returning officer, having concluded, majority decision, having concluded that the returning officer authorizes his power to have cancelled it, they move to the next level. That he also authorized, they declared the declaration of election conclusive null and void. They now declare the supplementary election null and void. It was not because the supplementary election was actually marred by corrupt practices. So the narrow issue is this: in a situation where results were not declared at the 7 polling units, is there any result to be cancelled? Not to go to the extent of somebody who cancelled it.
How can you say there were no results cancelled when the returning officer said the election was inconclusive?
No, it is the entire election of the state that was declared inconclusive. Consequent upon cancellation of result in the 7 polling units. Do you get the issue? Okay. Now the narrow issue now in the 7 polling units. The question which the appellate court will answer, and we argue with is that in those 7 polling units, were there results? Were election actually held there? At least in about 4 or 5 units there, no election was actually held. So the issue of who actually cancelled it, who has the power to cancel it, does not arise. That is what the minority decision said.
All right,
the majority decision said they present the case as if the election were actually held in those polling units and were actually cancelled by the RO instead of presiding officer. That is the narrow issue.
Okay, that's one perspective. So let's get another perspective from Abuja.
Well, thank you, Chamberlain. We're being joined in the studio now by Mr. Ni Owolade, and he's the former Attorney General of Osun State. You're welcome to the program.
Thank you very much.
Well, you've heard Barrister Kolakpo Alimi there. He's talked about the grounds upon which the judgment was annulled, and he doesn't agree with it. What do you have to say?
I'm surprised that maybe he has a mindset. You know, the judgment, the majority judgment, was a landmark judgment. And I must commend the two judges who decided, they were so courageous. And honestly, that time that the judiciary as the last hope of the common man is really apt in this matter. If you recall, let me tell you, you know, we have a history of election in Nigeria. We have the 1965 Operation Wete. We have the effect of the 79 election. Nigerians, the average Nigerian, if I may say this, is intelligent. The average Nigerian knows when an election is okay or it's not okay. We all know when we refer to the elections of June 12, 1993 as the best election. And I can tell you with all sense of sincerity and responsibility that the election, the so-called election of the 27th, the rerun election, 27th of September 2018, was the worst that ever happened. But thank God that those judges were courageous enough, bearing in mind that the returning officer, Professor Afwakwe, cancelled the elections in 7 polling units. And that was to be able to meet up, so that you now talk of being inconclusive. And there's a process, contrary to what my learned friend said there. There's a process. There's a manual, section 44.9 of the manual, of 2018 manual, shows the 16 steps to be followed by the returning officer. None in the 16, none, and I repeat, none, has there that the returning officer can cancel. It cannot. He doesn't have the power. And there are a line of authorities on this. When you don't have the power, you know, you cannot exhibit what powers you don't have. It is the presiding officer in the unit that can cancel. And there's a process. He has to sign, he has to fill the EC40.
There's landmark indeed, in the sense that cancellation has happened quite a bit in the elections we've witnessed in 2019, and a lot of people believe that whatever is decided on this Osun election matter, you know, might hold forth for the elections that have been conducted in 2019. They also talk about, but they ask whether the judges, because what we understand was done was that they now subtracted the votes for the 7 wards or so where supplementary elections were conducted from the total number of votes that each candidate had garnered, and that was how they were able to conclude that your candidate was now the winner of the elections.
No.
There was no such subtraction.
No, there was a subtraction, but even without the subtraction,
yes.
If you recall the first election, 22nd of September election, Senator Adeleke won that election by 353 votes. He already won. But because of the substantial non-compliance, whereby an unbelievable thing happened, and I think Nigerians should know this, honestly, because we must say enough is enough. And the 3, not even only the 2, the 3 judges made reference to this, whereby some officials of INEC will tamper. You know, you have, let me if I say this, you have the form EC80, that's where the results are filled in the units. We asked for the certified true copy. So we came to court not only with the form EC80, but also with certified true copy from INEC. There were discrepancies. Some juggling had been done. Some INEC staff must have done that juggling, whereby figures which are not in the pink copy which is the carbonated original copy, which the agents are given. You now have tampering, a situation where you have figures not there, now being put there. We brought 18 witnesses because, you know, it's not easy for you to come within 14 days because we had lots of witnesses also for the non-accreditation. So in this area of non-balloting, that column, the 8th column, which you have to fill, what we have in the pink copy, in most of the cases, were different from the certified true copy. So there were manipulations. What do you want the judges to do? I think it's about time because honestly, INEC should even go further if they want to really revamp. Because I think it's about time in Nigeria. Enough is enough. The INEC is supposed to be an impartial party.
You spoke of 3 judges. I think it's very important to put out there that the decision was reached, I mean, by 2.
By 2, but on this matter of manipulation, the 3 agreed.
Yeah, the decision was not unanimous on this matter because one of the judges felt that, you know, judges cannot be subtracting. It cannot be the job of judges to subtract, you know, from the figures that had been initially declared by INEC. They say that that has not, I mean, that has not been done before.
Oh, no. On the contrary, there are, you know, on the contrary, that's been done severally. You know, before we have lines of authorities on this. The point is that where you have substantial non-compliance, where you have manipulations, where you have the results sheets being tampered with. I'm talking now of the non-balloting. Obviously, the judges cannot close. What are they there for? And if I may say this, they didn't tamper, but they just decided. They were courageous enough to say, no, this is not right. As a matter of fact, it's criminal. And that's why I said that it's about time punishment must be meted up. Part of the problems we have in Nigeria is there is no sanction. We keep going back, we keep going forth and back. If some INEC officials, maybe with their co-conspirators, you know, coming to tamper with the result sheet. Because we found that out because we have the pink copy. The pink copy is different from the certified true copy. It's
very worrisome if that is true. I mean,
that's what happened. It's referred to. I can refer you to the judgment.
It is very worrisome. However, people will ask whether this judgment, do you think it will hold in the Court of Appeal?
Maokwe, I'm confident that it will hold. It will hold. It's bound to hold. You know, if you recall what Justice Kolawole in the landmark judgment, you know, that he delivered in Labour Party against INEC, where he even struck down Section 140, sub 2. He said the powers of a judge should not be limited. And he went further to say that each case, any election case, is considered on the peculiarity of the facts. What the judges did, they found serious irregularities, bordering on, like I said earlier, tantamount to criminal. And the judges said so, the fact that some people somewhere sat down and manipulating things, some left out, some not left out. It's unbelievable. It's mind-boggling. We're talking of an organization that's supposed to be independent, that's supposed to be unbiased. And then the judges would then close their eyes. The judges have the powers. I can say that again and again and again. That where there's such, because the law is, that's part of what our law says. Where substantial non-compliance, they were not, what had happened was not in compliance. There was substantial non-compliance with the dictates of the Electoral Act.
Pardon me, let me quickly get this straight. You say that you had a pink duplicate.
Yes.
On the pink duplicate that you had, the APC was already declared winner on that pink duplicate. Wasn't that right?
No, each unit. You see, when elections take place, election is actually in your unit. that is your polling unit. That is where the results will be given out.
Yes.
To the agents. And when the results are given out to the agents, your agents will keep that EC80. It's called Form EC80. That's the pink copy. That's to let you know this is what we scored in this particular unit. What happened in Osun is a sad story.
So let me get this straight. You have a number of Form EC80s.
We have Form EC8 for all the polling units.
Good. Now,
3,010 polling units.
We also know that when the final result is declared,
yes.
INEC will usually give you a copy of, where the addition and all of that was done, wouldn't they?
No, when, you see let me take it from the polling unit.
When, I get the polling unit.
Okay,
I'm talking about at the collation now, at the final collation.
At the final collation,
after
yes.
all the figures have been collated.
Yes.
Doesn't INEC give you another copy?
Yes.
To show you how they arrived at the final figure?
Yes.
They do?
Yes, they give you at the final, yes.
Was that not the final figure, was that not the final form you were requesting that's for the certified true copy?
Yes. We were given the final. Our agent, that's the state agent, will collect that final EC80, it's called.
Yes.
But the point that I'm making is that two issues here.
Did the figures tally on?
Two issues here. And I think it's important for viewers at home to understand this. Two issues here. The first one is that the returning officer cancelled, contrary to the guidelines, to the law. The returning officer does not have the power to cancel. And it's important that this is established once and for all, so that we put that at rest, this inconclusive nature. The point is, who has the power to cancel? Our witness, the star witness, PW74, was our state agent. Not only front-loaded, he alluded to this in his evidence, that, and this is very important, that it was the returning officer who cancelled. He was not cross-examined by the first, second, or third respondents on this. No contrary evidence was alluded. And the entire thing is contrary to their manual. Only the presiding officer can cancel. And it was through that cancellation that brought about this so-called supplementary election. So that is one issue. On the other issue, where you had 17 units, where you now had these 8 columns, just like the overvoting aspect also, where you have columns, purposely some columns were left blank. And then suddenly, we now found some things written in the other columns of the certified true copy. The issue is that, you have the bundle. Carbonated copies will be collected by the parties, the agents. Those carbonated copies will show what the score is, will show what you have inserted. But in most of the cases, you now have alterations from the certified true copy. So what has happened? And the 3 judges, not only one, alluded to this, that INEC, you better do something about this. You should not turn around, be changing after the facts, what we have as our result, should be what should be the result. In fact, I still remember that even the presiding judge, who gave the minority ruling, told the INEC staff, even after that, look, go to INEC and tell them that is an unwholesome part of the electioneering now. This must not be allowed to take place.
In whose favor were the conjured up figures? The alteration?
In favor of APC. I think it's in favor of APC. And what the judges did was to say, okay, since these serious irregularities, since this substantial non-compliance, let's take all the figures out. So you had, because we only, like I said, you have 14 days. There are so many others we have. But within the 14 days, we had to, shift our time, the overvoting issue, and then this other issue. So you now had 2,024 as that for APC and 1,000, over 1,000 for PDP. So those figures taken out from the entire score sheet. So I think, honestly, there are so many lines of authorities that it is. That's the effect. That's what the judges are supposed to do. Look, yeah.
We'll have to take a break.
Okay.
I want to ask you to hold your thoughts,
Okay.
and we'll continue when we come back from this break. Please stay with us. Mr. Ni Olade is still with us. He is a former Attorney General in Osun State. And we're talking about the recent ruling of the Election Petition Tribunal in Osun State, which returned Mr. Senator Adeleke, beg your pardon, as the governor-elect of the state. Give us a status update. How does this work? I mean, we see the tribunal's rule, but it doesn't seem to take immediate effect. How is that?
Well, what is important for us is that we have judgment on our side, and we have the enrollment order.
I'm asking you that question as a lawyer, because I'm sure a lot of Nigerians are curious as to how this works.
As of today,
yes,
the law is that Senator Ademola Adeleke is the governor-elect of Osun. And the enrollment order says it all. You know, there are 6 paragraphs in that enrollment order, where the first one says that Mr. Agboyega Oyetola was not duly elected.
Yes, I understand all of that. The thing is, when does this come into effect?
Well, it's immediate, because if you look at number 5, the 5th one, it's ordering the first respondent, that is INEC, to issue a fresh certificate of return to Senator Ademola Adeleke forthwith. It's immediate. Cancel this
what is holding,
and add this.
What is holding that immediacy?
Well, I assume that we got the judgment on Friday, and today is Tuesday. We sincerely hope that INEC should obey the court order, because there's a court order to that effect. And shortly, I assume that they will do the needful.
This is not because the matter is going on to the Court of Appeal, and perhaps your opponent would have gotten an injunction stopping that particular order.
Well, there is no injunction.
That you're aware
of now, that I will know if there's an injunction. There is no injunction anyway. And there is an order of the court. I'm more particular about that order, which says that cancel one certificate of return to issue to Mr. Oyetola, issue a fresh one immediately. And honestly, this is part of our jurisprudence, which I think it's very important. The order of a court must be obeyed in all climes. It's part of, in the civilized world, when you say there's an order, no matter what that order is, you obey that order until the contrary.
Let me quickly take you to this minority judgment by Justice Mohammed Sirajo, who says that even when non-substantial compliance affects the outcome of an election, the tribunal, by virtue of Section 140, subsection 2 of the Electoral Act, does not have the power to subtract the votes affected by the non-compliance from the scores of the candidate and announce a winner. According to him, the tribunal only has the power to nullify the results of the polling units affected by the non-compliance and order a supplementary poll. Do you agree with him?
No. In fact, I'm surprised that Justice Sirajo, with due respect to him, because I know he's a senior judge, and I'm surprised that he could have said that, bearing in mind that on the 21st of July, 2011, Justice Kolawole, because I still refer to that, in Labour Party against INEC, struck down Section 142. Since 2011, no superior court, it has never been overturned. As a matter of fact, this issue came to the Supreme Court at one time, where Justice Fabi JSC said that, declined to go into that. The point I'm making is that it has not been overturned. The issue is the judiciary. What Justice Kolawole is specifically saying is, you cannot, once you have a judge in place, you cannot delimit the powers. You cannot derogate the powers of a judge to perform his function. It's contrary to Section 4(8) of the Constitution of the Federal Republic of Nigeria and Section 6 of the Federal Republic of Nigeria, of the Constitution of the Federal Republic of Nigeria. The powers of a judge to be able to deliver judgment cannot be curtailed by an act of parliament. Once you have anything, Section 1, sub 3 of the Constitution is clear about that. That is inconsistent with the Constitution. Of course, the Constitution will prevail.
So you have no qualms that this is going on to the Court of Appeal?
We are prepared. Look,
Okay.
we tendered
Even
1,013 documents. We brought 84 witnesses. We are prepared all the way to the Supreme Court.
Okay.
We are confident. We are confident.
It's a good place to leave it. We have to thank you for coming on Sunrise Daily. Mr. Niyi Owolade is a former Attorney General of Osun State. It's back to you, Chimberling in Lagos.
All right, yes, indeed. Thank you, Mark. Well, coming back to this now, you heard what he said about those. So what's your response to it?
Well, it is quite unfortunate that, with greater respect to Barrister Niyi Owolade, that a counsel of his repute will be arguing on the national television like channels that the judgment take is effect immediately. By virtue of provision of Section 143, subsection 1 of the Electoral Act, which is almost the Bible and Quran that guides the election, the judgment will be put in abeyance until after 21 days.
Even though it says immediately.
The immediately is in that judgment. Whatever that judge said is in that judgment. There are provisions said if the owner of that office, until he fails to file his or appeal within 21 days, the judgment will not take its effect. So when we want to argue, we shouldn't put sentiment. And let me now come. So that position is very, very wrong. Our people and everybody to go and check the provision of Section 143, subsection 1 of Electoral Act 2010 as amended. And I stand to be contradicted.
Okay,
so
but
that position is very, very wrong.
That's on the one hand. When you say he's wrong, were you not also wrong when you say that it's never been done in law, where you said the judgment would be, what, subtracting votes?
No, I'm coming to that. Let's take the issue one by one. He has raised a lot of issues.
Yes, but before...
That issue is settled.
No, let me...
That issue of the judgment taking effect.
Yeah, that's a separate matter. But concerning this one, what would you say? Because, I mean, several states have told us that, look, in Ngige versus Obi, as reported in Part 999, Nigerian Weekly Law Report, it counters your perspective.
That...
What you say that it's never been done in law, that they will now come and subtract votes.
No, I've not come to that one. Now coming to the issue of subtraction. The law distinguishes between corrupt practices and non-compliance with the Electoral Act. The law distinguishes. If it is corrupt practices, like disruption of an election, over-voting and so on and so forth, or counting of invalid votes, when you see provision of the law and the statement, go and read it.
Cancellation.
I'm coming to it. Or counting of invalid vote. That is in a process where some votes that were actually for it. Let me land this. Let me come my thought. Were counted for a particular candidate. And you get to tribunal and discover the law permits the tribunal to deduct those votes and make the declaration. But when the issue is non-compliance, like filling of forms, and then coming to the unit very late and some other issues, that is not majorly, when you see most of the effect, is that of the INEC, it's non-compliance. When the issue happens to be the actors on the field, it's corrupt practices. So the law distinguishes. When it is non-compliance, you will now go whether it's substantial enough. If it's substantial enough, then what you do is rerun.
So what happened in the case where all the judges agreed that some of the results were tampered with?
Let me now come back to that. It's quite unfortunate that our people, we take advantage of the error in the system. The resource sheet, the original on top, the carbon copy, the other copies were carbonized. Now, as it goes down, it becomes fainted. That's what happened. Ask your people who were on the field.
So fainting, are you saying that they misunderstood the fainting for alterations?
No. Coming to it. That's this point I'm making. Now, there are two situations here. Becoming fainted. For the 17 polling they are talking about, the pin copy given to the INEC, they were actually fainted on some columns, not because they were not filled. And it reflected on CTC. And let me ask you, why should anybody go and alter the column, the topmost column, when he leaked the score, and the agents that were at the various polling units from the beginning, as I'm here now, of the election till the end, said election in my unit went on freely. Their agents, accreditation did, voting and so on. So, do you have any other complaint? You look at the result between the two seats. I'm coming. The results are the same. Now, in another instance, we have what they are now complaining of. The law by paragraph 33 of the guideline, realize that the INEC might want to do some reconciliation. They now said at the Ward Collation Center, when they get there, the Ward Collation will now look at the result brings by the party, by the presiding officers. If it discovers that there are collations, there are reconciliation to be done, the law permits the reconciliation to be done at that level. If we had the reconciliation was supposed to be done, the election should be cancelled. Okay. Now, the reconciliation will have to be initial. But in that kind of situation, it will not reflect on the pink copy. Because the pink copy has been given to the party agents. Okay. Now, let us now come back to this judgment. Instead of us inputting our own sentiment and go back history.
Let me bring you back to this before you come and read that, because of our time. I want to squeeze in as much as possible.
Yeah, thank you.
Well, the majority judgment, don't forget, it also held that the returning officer who cancelled the results in the affected units after the result had been announced had no power to do so.
Let me now correct one thing. Yeah. That is the error of judgment you are talking about. The election is a process, start from the unit, and hence with the returning officer. A situation whereby there is a result at the polling unit. The returning officer of the state lacks the power to cancel it.
What's the process?
I'm talking about that is from the unit. Election is from the unit to the ward, from ward to the local government, from the local. I want to put the local government to the state.
What he said here is not just to cancel it, but to cancel it after the result had been announced.
That's what I'm now saying. So what's the error? Let me now point out the error so that our people.
Go ahead.
That's you. Now, in a situation whereby this is hypothetical, it's not applicable here, whereby the result has been declared in a polling unit, the state returning officer will not have the power to cancel it. But in a situation whereby election did not hold in a particular polling unit, it is the state returning officer, based on the report submitted to him, that will make the pronouncement.
Without conferring with the resident electoral commissioner?
No, it doesn't. That's not the issue. That's not the issue.
Okay, so he has the power to cancel the result, and not that the tribunal can cancel the result after the result has been announced.
No, I said in this instance. Let me read the judgment. The result in this 7 polling unit, were any result declared? That is the question. No result. They gave the state returning officer the report that in 7 polling units. And they gave the reasons. Look, it was so live now. The election could not be held for social reasons. And based on that one, is they want to make the pronouncement. Now go to page 189 of the judgment. If you
quickly, because we need to go.
Now, what the petitioner actually put there, it's quoted, paragraph 24 of that petition. It's on page 189. It says, your petitioner has found that the first respondent cancelled the result of the election in 7 units, namely units 1 and 4. He mentioned the units. Now said for the following reasons. Even that's the petitioner. A, disruption in the aforementioned unit in the local government area. When you yourself stated that the election in that place has been disrupted, do you have any result? The answer is no. Now coming to the second one, malfunction of card reader in the aforementioned unit in the South local government. C, over 40 in the aforementioned unit in the North local government area.
Okay. We need to wind down.
No 40 took place.
Now
what I want to say, the point is this: since the result in those 7 polling units were not even available, they only gave the report of non-availability of the result in 7 polling units to the RO.
The argument will keep going back and forth because
this is
now we have people.
Don't get it.
No, hold on. We have people who are even saying that there was no need for rerun in 5 unit 17. In Oshogbo because the election held. So it will keep going back
and forth. And look at the minority. They say if the election were to be held, in those places. It is for the petitioner to tender
Well-
the result of the election.
Well, you're headed to appeal. So
that is an issue. We just want to
we'll
make
see
it
what
very clear
happens.
to the people
So the
that
strength of your appeal now is in the
All right,
minority judgment.
Thank you very
Kolapo
much.
Alimi is the former commissioner for local governments and chieftaincy affairs for Osun State. Is also a lawyer. Thank you for coming on this morning. I
Thank
wish
you
you all the
very
best.
much. Thank you.
All right, so back to you now in Abuja.